Okay, I think we will begin. Good afternoon, everyone. I'm Lissy Medvedow, Executive Director of the Rappaport Center for Law and Public Policy at Boston College Law School. On behalf of my colleague, Cindy Nguyen, and Professor Dan Kenstrom, Faculty Director, and my partners and colleagues at the Rappaport Institute for Greater Boston, Executive Director Catherine Carlson, Associate Director Polly O'Brien, and Jeff Liebman, Faculty Director, welcome to the fourth and final debate of the Greater Boston Debate Series of 2021. We launched this new initiative this past spring to provide a forum for raising up important public policy issues. So far, we've taken on qualified immunity for police, free public transit, and rent control. Today, we are going to explore the Commonwealth's public records laws from the perspective of whether transparency promotes or hinders democracy. That's all I'm going to say about the topic, because we are truly fortunate to have as our moderator a reporter who knows the ins and outs of Massachusetts policies and politics. I'm delighted to introduce Shira Schoenberg, a reporter for Commonwealth Magazine, where she covers Beacon Hill, including the State House, the governor, our courts, and our legislature. Shira previously worked at the Springfield Republican Mass Live, covering topics as diverse as the launch of the legal marijuana industry, child welfare, and US Senate elections. Shira won the Mass Bar Association's 2018 award for excellence in legal journalism and has had several stories win awards from the New England Newspaper and Press Association. She's also covered 2 New Hampshire presidential primaries, one for the Boston Globe and one for the Concord, New Hampshire Monitor. She holds a master's degree from Columbia University's Graduate School of Journalism. Shira will introduce our 2 debaters, our panelists, our esteemed panelists, and we'll be reserving about 10 minutes at the end for questions and answers. Please use the Q&A function to pose your questions. Matt Victor, a third-year Boston College law student and founder of the Good Governance Project at BC Law, a co-sponsor of today's program, will handle the Q&A. We are recording this program, which was Matt's idea. So with that, I am really delighted to turn it over to Shira and to thank Senator Becca Rausch and Professor Raymond LaRaja. So Shira, take it away.
Thank you so much, Lissy. And thank you to the Rappaport Center for Law and Public Policy, the Rappaport Institute for Greater Boston, and Boston College Law School's Good Governance Project. I'm Shira Schoenberg of Commonwealth Magazine, and today I'm excited to host a discussion about legislative transparency. For years, advocates have been debating whether our public records law is adequate to ensure public accountability. The last couple of years in particular, there's been a lot of focus on the Massachusetts House and the lack of openness in some of its procedures. This is a particularly hot and timely topic since just this week, the Progressive Democrats of Massachusetts put out a new report criticizing the Democratic-led legislature for lack of transparency in areas like committee votes. Here with me today are Senator Becca Rausch and Professor Ray LaRaja. Senator Rausch was elected to the Senate in 2018 to represent the Norfolk, Bristol, and Middlesex district. She chairs the Committee on Environment, Natural Resources, and Agriculture, vice chairs the Committee on State Administration and Regulatory Oversight, and is on the board of the Caucus of Women Legislators. She is a lawyer who held positions in the Baker and Patrick administrations, and she's been a leading voice calling for good governance and government transparency. Professor LaRaja is Associate Dean at the College of Social and Behavioral Sciences and a professor in political science at UMass Amherst. He's also the Associate Director of the UMass Poll. His research focuses on political parties, elections, and political reform, and he is the founding co-editor of The Forum, a journal of applied research in contemporary American politics. Interestingly, the 2 of you have actually debated this topic before in dueling op-eds for Commonwealth Magazine. Senator Rausch, you argued that the legislature needs to be more transparent, while Professor LaRaja, you argued that transparency can actually hurt legislators' ability to deliberate privately and get to a good result. And I'm hoping that we can hear more from both of you about these arguments. So Senator Roush, why don't you kick it off and take about 5 minutes to talk about these issues, and then turn it over to Professor LaRaja for his opening comments. And then we'll get into the questions.
Well, thank you so much, Shira. Good afternoon, everyone. It is such a pleasure and a privilege to be here with all of you. I hope everyone here with us today, both as panelists and as hosts, and all of you watching by live stream are staying safe and well through these continued pandemic living conditions. Special thanks, of course, to the Rappaport Center for hosting today's conversation, and to Professor LaRaja for participating in what I'm sure is going to be a lively conversation today with me. I'm really excited to get going. As Shira mentioned, I am currently in my second term serving in the Senate. Prior to my election, I worked for over a decade as a practicing attorney, both in the public and private sectors. I'm formally elected at the local level, prior union steward, and also a previous law professor. And so my areas of expertise include health law and policy, in addition to information governance, knowledge management, and data privacy and security. And in fact, my prior work in government was as the first ever electronic discovery attorney in the history of our executive branch. And one of my roles when I was at EOHHS was to lead a team of people who actually implemented and worked on the protocols to implement the new public records law when it came into effect in 2018. I've lost track of time. Whatever year that was a big project of mine when I was working in the executive branch, and I have brought that knowledge to the legislature now. And a big component of my legislative portfolio is indeed good governance and strong democracy, including transparency and accountability. I firmly believe that our democracy is strongest when it is transparent and accountable to the people. Those of us who are elected to the state Senate and my colleagues in the House of Representatives, we all work for and serve at the pleasure of the residents of our respective districts. We got to these positions because thousands and thousands of people voted for us. At bare minimum, all of those people who voted for us deserve to know how we are voting on their behalves. And that is a huge part of how we are maintained accountability to all of you. Transparency makes the legislative deliberate process more robust, with voters being in a position to question and challenge the action of their elected representatives or the inaction of their elected representatives. And after spearheading the candidate transparency pledge during the 2018 election cycle, I am proud to now be the leading legislator on successfully advancing transparency on Beacon Hill, having achieved advancements in transparency both on the floor and in the committee process. Now, last session, it's my first session, I served as the chair of the Joint Committee on Municipalities and Regional Government, and I was very proud to make sure that our committee rules included a provision to allow residents of the Commonwealth to get voting records from the committee by email request. There was only one other committee in the entire legislature that did that. That was the Joint Committee on Children, Families, and Persons with Disabilities. Otherwise, you had to actually show up in person at the State House to request committee vote records in person during business hours. So again, only two committees, and that was a change that I was able to achieve in the first few months of my tenure in the Senate. Now, of course, everything is by email because of the pandemic. So in a certain way, we've moved forward. But overall, I think, unfortunately, we've taken a step backward. We have no joint rules in place, which I find deeply frustrating. The committee rule process is kind of held in limbo because we do not have overarching joint rules between the chambers, between the House and the Senate. And indeed, the sticking point does seem to be transparency on votes, with different approaches in both the House and the Senate versions of the joint rules. And disclosure of committee votes and committee testimony, therefore, depends on the committee chairs. And it's important to note that official committee records are kept by the House chair. So there's no guarantee that the public can find out about how a particular rep or senator voted on any particular piece of legislation in the committee process. And indeed, there's no guarantee you would find out how anybody voted on the floor either, unless if a bill even makes it to the floor. And there are over 7,000 bills filed, and a very small fraction of them make it to the floor for a vote. But all of the ones that are timely filed get some kind of committee action. But votes on the floor also are done by what's called a voice vote, unless there's a specific request for what's called a roll call, where they actually call the roll out. In the Senate, they literally call all of our names, and we have to vote out loud. Now, there are various things that each of us as individual legislators can and do with increasing frequency to ensure better transparency and accountability. For example, I publish all of my votes, both on the floor and in committee, on my website. Several of my colleagues are doing the same, and we're seeing increasing number of people do that. I had notable success achieving support and sort of shifting culture around making more roll calls happen in the Senate, and we saw an increase there as well, at least until the pandemic hit, and then everything got turned on its head. I've also filed two pieces of legislation that I'll make note of before wrapping up here, because I think I'm coming up on my time. But Senate 2107 is an act expanding the public records law. This bill would do exactly as the title says, expand the public records law to include the governor and the legislature, neither of which are currently subject to our public records law, which of course in turn means that constituents lack access to documents that are part and parcel of the work that we do as state government elected leaders. Massachusetts is the only state in the entire country where both the legislature and the governor's office are exempt from the public records law. There are a couple that exempt the legislature, but not the governor. But overarchingly, Massachusetts is by this measure the worst in the nation in terms of transparency and accountability. The least transparent, the least accountable. The second bill is Senate 2108, an act regarding information governance. And this largely came from my work and experience in the executive branch. We have widespread flaws in knowledge management and information governance, which in turn leads to a pretty significant set of challenges and also drastically higher costs with regard to public records law, public records disclosures. And so because we're having record retention and record management issues, it becomes much more difficult for public records requests to get responses. And I'm happy to get more into the details on that if the questions and the discussion warrant. But without this stronger information governance, knowledge management work, it will continue to be very burdensome and expensive for public records to be disclosed, as the public records law, even in its current iteration, requires. So much work to do and much transparency and accountability to continue to enhance. But at bottom, again, we're all here in these seats because thousands of people voted for us, and all of you who voted for us and the people who didn't vote for us too, all deserve to know how we are fulfilling these roles to which this great responsibility on your behalf. And transparency and accountability, improving the public records law, enhancing democracy, all of that comes hand in hand. So again, it's a pleasure and privilege to be here with you today, and I'm really looking forward to a fruitful conversation.
I guess I could just jump right in. Okay, thanks. All right, well, thank you. Thanks for inviting me. I'm happy to be here. And it's a pleasure to be debating Senator Roush, who's already done a lot of good work with transparency when she was in the executive branch. So I'm kind of taking on the role of Darth Vader here in opposition to efforts to make government transparent in all ways. So let me just affirm that I do believe transparency is essential to democracy. Voters need information about government when they make decisions. So when they go to elections, they know who to vote for, to exercise their rights if they disagree. And Americans have a broad commitment to transparency. It's in our bloodstream. It really is. We don't trust those people in government. Going back to the founding, we want to watch them closely. But let me argue against apple pie for a moment. Okay. Transparency can be too much of a good thing. And I want to make two basic points. And it's mostly about trade-offs. First, there is a balance that needs to be between accountability and efficiency. If we monitor government all the time, officials are unable to make decisions or must vote on everything before them. Government slows down to a crawl if we do this. Lots of bills get introduced. The senator just said 7,000 bills. The institution needs a way to process these quickly sometimes. And that means you don't vote on every aspect of a bill or amendment. And think of this especially during a time like the pandemic. And even other issues like, helping the poor people get low cost fuel in winter, you need a responsive government. And that's very hard. And I'm also concerned, here's a big thing for me, about how sunshine affects the deliberative process. I think it's hard or harder to compromise with members who don't share all your preferences. And I'll say more about this later, perhaps, when everything you say can be used against you in the next election, even if you are just floating trial balloons to try to find some possible compromise. Okay, so that's the first thing between accountability. The second thing is, I wonder sometimes the question of who really benefits from increased transparency. So the average person doesn't have time to monitor government. The field is typically left to the press and to interest groups. And of course, I think it's good for the media and groups to have access, but consider that the press have their own standards for what's newsworthy. They want to attract eyeballs, and often could be a scandal or hot button issues. This is, of course, Shira accepted, that attract attention rather than some of the real arcane policy issues that face the legislature. So I'm less worried about the press doing their job and gaining access than I am about some of these highly selective groups that monitor government. It's often lobbyists, business, or issue advocates who have their own narrow agenda, and they monitor things closely. And sometimes they can warn their members, they mobilize, they can shame legislators who might look like they're compromising, which in fact they should be in many cases. They can throw sand in the gears for potential laws that might end up being good, even if they don't satisfy the needs of these particular groups. Let me stop there, but those are my two basic points I wanted to make.
Senator Roush, you made a very strong case there for the importance of legislative transparency. How do you respond to the point that Professor Raja just made about legislative efficiency? Will you be able to get things done if every word is monitored, if there's more requirements for open access?
Thanks for the question, Shira. I think it's important to understand what we're talking about here. No one is talking about every single word. That's not even what the public records law says currently about the executive bodies that are subject to it now. We're talking about specific documents, and in the legislative context, we're also talking about voting records. And I should add, and this piece somehow manages to get missed almost all the time. There are a very long list actually in the public records law of exemptions, right? Documents that are exempted from publication, including private information, right? Addresses, phone numbers, personal information about employees, documents pertaining to security, right? Building security, trade secrets. There's a very long list in the general laws of materials that are exempted, including particularly salient to the professor's point, documents that reflect the deliberative process. And by the way, no documents get created if you're having a conversation, right? Unless that conversation is recorded, of course, such as this one, for example. So it's important to make sure that we're not conflating unbridled transparency, as the professor has posited, with what we're actually talking about in terms of promoting and advancing transparency and accountability. And the question as to efficiency, at this point, everything gets a vote at some point if it is a timely filed bill. Now, it might not be this particular aspect or that minutia element, but every bill that is timely filed gets a vote one way or another through the committee process. And the absence of committee voting records has led to this proliferation of focus on co-sponsorship of bills, for example, which, by the way, is not a particularly good measure as to whether a senator or representative supports the guts of that bill in the long run, right? We've had members of the legislature who have co-sponsored legislation and then voted no when it got to the floor, and members of the legislature who have not co-sponsored things for a variety of reasons, but would vote yes on the floor. For example, I'm the chair of the Joint Committee on the Environment, Natural Resources, and Agriculture, and part of what I consider my responsibility as the chair of that committee is to withhold co-sponsorship, right? Not co-sponsor bills that come before me as chair of this committee, because my job as chair of this committee is to consider each bill on its face, on its merits, and assess all of the various different arguments and perspectives, and then make a decision about what that bill, what that bill's path forward should be. So I try to not co-sponsor bills that are coming before me on the ENRA committee, and frankly, to a certain, although lesser extent, also on the State Administration Committee, where I serve as the vice chair. So there are plenty of ways for votes to go forward. Votes happen, again, on every single bill. Does a recorded vote on the floor happen on every single amendment? No, but that's also, again, not what we're talking about here.
And Professor Araja, I was actually fascinated by your argument that allowing more transparency would give lobbyists more sway. I was hoping you could just defend, why is that a problem? Isn't part of the job of the legislature to hear from all competing interests, read lobbyists, and then decide how best to balance those competing interests to come to the resolution that is best for their constituents?
Well, yeah, the big issue here is, do those lobbyists represent all members of the public? I have a feeling that the ones who are on side of Beacon Hill, who would be really tracking those votes, are not necessarily broadly representative of groups. The selection bias of groups at the State House is a concern of mine. And so I feel it's good for members to have a little bit of insulation so they can kind of keep those lobbyists off, and they know their membership, they know their districts better than anyone. And they can make decisions without some lobby saying, hey, you're voting against our interests. Let's figure out a way to make you look bad. And it's particularly concerning to me voting for committee. I mean, I think the committee chair should have some discretion in the people within the committee, because a lot of times what goes on in the committees is not what ends up in the final bill. So you might look bad and that'll be used against you in election. Fortunately, Massachusetts is not a very polarized state. But let me give you a place like California or Wisconsin, where, so thinking long term, you take those little snippets like they do in Congress, and you show that in the next primary or general election, and it's really an unfair charge when somebody makes a decision in committee that ends up changing because they decide to compromise. That happens all the time on procedural votes. So,
Sarah, could I respond?
Sure.
Thank you. I want to respectfully disagree that Massachusetts is, with the assertion that Massachusetts is not a polarized state. I think we have a lot of polarity here, and we've seen a drastic increase in polarity, especially in the last couple of years. But that is probably a debate for another time. I do agree with you that bills change throughout the course of the legislative process, and that is, of course, an important piece. But I pretty notably disagree on the point that deeper transparency gives power to lobbyists or interest groups, because our current status quo actually means that the lobbyists are the only ones with insight or power. They're the only ones that, at least not at the moment, but in normal non-pandemic times, really walk the halls and hear the whispers of the State House and know who's doing what. And without committee, public committee votes, without the legislature being subject to the public records law, ordinary folks, right, non-lobbyist folks, they have day jobs. They have to, and they take care of family. And so they don't have the ability to come into the State House every day and kind of weave in and out and hear what the walls are whispering. So without us enhancing transparency, in fact, all we're doing is perpetuating a system where lobbyists are the only ones with power about and knowledge of who's leaning which particular way, right? And with respect, I just wholeheartedly believe in the power and capacity of Bay State residents. There are a lot of very capable Bay Staters who don't choose a professional career as a lobbyist, who are plenty able to make sense of governing information, understand votes, ask good questions, and organize with friends and neighbors and like-minded Bay Staters across the Commonwealth. And we are doing a detriment to that ability, not because of any individuals, any residents' capacity to do so, but because we're not giving them the information that they need.
So let's dig into one of these issues that you both have mentioned, which is committee votes. And this is something that's actually changed recently. In the old days, I actually once did a story where I tried calling the Senate chair and the House chair of pretty much every joint committee or every major committee and said, here's a bill, how did the members vote on it? And it was fascinating. Most of them gave me the information. Sometimes it took a few phone calls. A couple of committees didn't get me the information. They said it's our policy not to give it. And at one point, I think I was also told, we'll give you some of the information, the people who voted in one direction on the bill, but not the other direction. There have been some changes under the recent rules change that the House voted on earlier this year. You can find out who voted no in the committee recommendation, but the names of the people who voted yes are lumped together with those who can't vote. So bottom line is you kind of can usually get the information about who voted which way in a committee process. It's not always that simple. Senator Rausch, why is it so difficult to get what seems like should be a basic piece of information?
Yeah, I'm not sure. But what I think the best way to think about this is that culture change is hard. And committee votes have not been public for a very, very long time. The Senate, however, does make all of our committee votes public, whether or not someone voted and which way they voted if they did vote. Right? Every Senate committee publishes their votes on the website. And again, this is the sticking point, or at least one of the public sticking points between the House version and the Senate version of the joint rules. Right? The House iteration of the joint rules depicts the committee vote publication, record publication, just as you described it, Shira, where the yes votes and the absence of votes are sort of lumped together in a tally, but the people who vote no, right, against the recommendation of the committee chair, those are made public, or at least that's the proposal from the House. The Senate proposal is to just publish all the votes, regardless. So I'm not being a member of the House, it's difficult for me to speak to the thought process behind that my House colleagues are sharing about that. But for a very long time, and as you pointed out in the introduction to this question, Shira, committee votes were rarely public for a very long time, long predating me. And culture change is hard. And that's part of why, last session when we were all in the chamber before the pandemic, every time somebody asked for a roll call vote on the floor, I stood up. Every single time. And often it was me and all of the Republicans, right? And I was cool with that. And all of my Democratic colleagues knew that I was going to do that. And lo and behold, slowly but surely, my Democratic colleagues who sat next to me in the circle in the Senate, everybody started standing up with me. And, and that was just it was a wonderful thing to see. And I wasn't asking anybody to stand up with me, but they saw me doing it. And over the course of a year, people started joining me and slow but steady culture change.
And I will clarify that votes taken on the House and Senate floor are all public. So those are all easily accessible on the legislative website. And given that, Professor Laraja, is there a reason not to make the committee votes available online? Do you see a benefit to that?
Yeah, well, I think I want to go back to this. The senator mentioned that the Massachusetts is already polarized. It's less polarized than a lot of states I mentioned, but I think it'll often make it worse to have this type of transparency, especially in some of the most thorny issues that are being undertaken by some committees, which really need a lot of robust private conversations. And I know there's private conversations that go on outside of committees, but I think committee votes can be distorted. And it's not only about the policy issue, and they're often out of context. So, my constituents, say, for example, my constituents want me to help with small business, but they don't like more taxes. So I'm willing to negotiate somewhat on higher taxes with someone like Senator Roush, if I know, other colleagues will support my small business plan. But if I vote in committee that I want higher taxes, I'm a dead person with some of my constituents, and it'll be used against me when it's unfair, because the final bill may not even have that. And in fact, I would argue if we're going to have committee votes, one problem is committees aren't powerful enough to be gatekeepers. So much changes at the end of the process. It's really, sometimes it could be a shot in the dark. So I'm not opposed. It should be left up to the committees. But I think the real power of accountability comes from retrospective voting. Is my member on the floor supporting things and explaining to me why they made those compromises? That to me is the most powerful form of accountability. Some of the other stuff is nitty gritty, and we count on the press to explain some of that nitty gritty. Again, I would give the press more access, but things that get taken out of context in the deliberative stage, deliberative bodies. I'm really concerned about our institutions in America. They need some boundaries, because otherwise they can't function. If they become too porous and everybody can have a say without some gatekeeping function, we're not going to get things done. And we're not going to trust each other within the institution, because people will be posturing and shaming us. Again, I point to the US Congress as primo example.
So you're distinguishing basically between the process and what happens behind the scenes to get to the bill versus the final outcome and their position on the final outcome bill.
Yes, that's an important distinction. That's a really important distinction.
Senator Roush, do you think that, sorry.
Well, I was just going to say one other thing. When we do social psychology, research shows people are much more likely to listen and accommodate others when there's a private space between them, and they can talk frankly in committee. And this is paradoxically, it's especially important for conflictual issues to have this type of space where there's less media coverage and less interventions. And then voters should judge them on the outcome. I don't like that outcome. And people like Senator Roush should be accountable for explaining why she compromised. To me, that is the essence of a good deliberate. They don't, the old saying, they don't necessarily have to see where all the sausage is being made. What does it look like at the end of the show? Now, I don't take that to an extreme, but I do think some issues need a little bit more discretion.
Senator Roush, do you agree with that distinction between the sausage making and the actual sausage?
So I thank you for throwing it back my way. I again want to make sure that we're talking about apples and apples and not apples and oranges, because no one is, or apples and ice cream. No one is talking about or even suggesting that private conversations would magically become public. No one has offered that, including me. And those private conversations are important because people do need to be able to ask questions and not be slammed for those questions later. But at bottom, the bare minimum of what we are elected as legislators to do is vote. It is the absolute bare minimum. It's something that people love to talk about in campaigns. I have 100% voting record. I've never missed a vote. And by the way, that is true for me. I have never missed a vote. But at some point, you have to make a decision. And the committee process is part of that. Decision-making is one decision-making point along the legislative process spectrum. And yes, it is true that people do have those private conversations, and people would continue to have those private conversations if the voting records were made public. And again, no one's talking about taking that process away or installing cameras in every single room in the State House. That's no one has suggested that. And so it's important to make sure that we're actually talking about what the actual suggestion is, right? Which is that those voting records become public, right? And that the legislature is subject to public records law. And again, I want to stress again that there is an exemption in our public records law already for documents pertaining to the deliberative process. This is the same point that the professor keeps making, but in fact, protections to ensure that those honest And sometimes vulnerable conversations can happen so that legislators can get the information they need in order to make decisions. But again, at bottom, that is the very base of our job. Make decisions, make judgment calls, and cast a vote. And we should absolutely have to have conversations with our constituents about why we voted a particular way. And whether that vote happens on the floor or happens in a committee process, the engagement with constituents is exactly the same. And I want to just again stress that the number of bills that come to the floor is a tiny fraction of the number of bills that move through this body at earlier stages of the process. And there's a good reason. There are lots of good reasons for that, right? Maybe the bill isn't ready, right? The bill just isn't ready to go to prime time on the floor. But that doesn't mean that the base policy or the base pieces are not worthy of attention. They are, and they get that attention in the committee process. And I have certainly had lots of conversations with constituents about votes that I took on the floor, and frankly also votes that I've taken in committee.
There's one more specific legislative issue I'd like to discuss quickly before we get on to the broader issue of the public records law. And because I think it's something that plays into a lot of, particularly what you mentioned, Professor Raja, about the lobbyist influence, and that's committee testimony. There's been a similar discussion about the testimony that's filed with the legislative committee. Today, it's up to committee chairs whether to release a copy of that testimony. We're talking, there are public hearings, but we're talking about also written testimony. And in my experience, and again, one reporter's experience, sometimes staff will just send you an email, say, here's all the testimony that came in on this bill, go take a look. Sometimes they'll say it's not our policy, it's not available. Professor Raja, I would think that allowing access to committee testimony might actually shed some light on what you were referring to about lobbyist power and who is influencing the lawmakers on a particular policy. Do you think that there are benefits to making committee testimony public? Are there costs to making this testimony public?
Yeah, that's a really good question. And it's a tough one to think about. Overall, I do think there's benefit from making testimony public, because you want to see which interest groups are supporting for and against certain policies, who's weighing in, and the public should get that information. The potential downside, if you want to talk about, is you forcing interest groups or experts to take positions or not. Let me think of an example. An expert gives an opinion, it's nuanced about a controversial or very complex issue, and you think about this. The legislature doesn't have executive privilege, but sometimes you need unvarnished advice to make your decisions. And I think some experts would be reluctant to give their unvarnished advice if they knew it was going to be public and they were going to be pilloried for it. I think some of them would just rather say, hey, this is probably not a good idea for these reasons. I know some people support it. I know the majority of the voters might support it, but it's going to be bad policy and it's going to hurt people in the long run. That would look bad for an expert in newspapers. So I think it's okay to do that. It could look really bad in news. People could be called out for being cruel, selfish, whatever. It's a tough trade-off. It's a really tough issue for me. In most circumstances, I think it should be made public, but I do think the leadership should have some discretion at times.
So Naresh, do your committees make testimony public, and do you think it should be made public?
We actually did have a request for a piece of testimony, a piece of written testimony, and we provided it. This session, I'm thinking of one circumstance in particular. So again, I come back to, so I also want to make clear that the hearings are in fact public, right? And this is one of those kind of silver lining moments about the pandemic, right? All of the hearings, the legislative hearings have gone online, right? We don't use Zoom, we use Teams, but you can watch and they all get live streamed on the website, and you can go back and watch the archived hearings as well. So anyone who testifies live, right, orally, that is public already. The written testimony, again, I think the default rule should be that written testimony also should be made public. And I want to recall attention back to those exemptions, right? There are some bills that that we take up that are deeply controversial and also deeply personal. For example, the legislation to ban child marriage, legislation pertaining to domestic violence, legislation pertaining to to curtailing abuse within our penal system. Right, there are a slew of pieces of legislation that we passed last session about conversion therapy. That these are critically important pieces of legislation that also need some discretion and privacy to ensure that people can tell their stories so that we as legislators can hear it, but also that we're not putting anyone at risk and violating anyone's privacy and confidentiality. And those exemptions are in fact, again, already baked into the public records law.
So let's talk more about the public records law.
Can I ask a
Massachusetts.
follow-up question? Just a follow-up question. Who adjudicates those exemptions in the legislature? Can you just?
The legislature is not currently subject to the public records law, so so there isn't an official process for how to do that.
Okay.
So yes, as Senator Rush said, Massachusetts, I believe, is the only state that has exemptions for all three branches of government. Although state agencies are fall under the public records law, the governor's office does not, the legislature does not, and the judiciary does not. And there was some effort to update the public records law in 2017, made some small changes, things like concrete timelines for agencies to respond, some cost limits. There was a committee formed to look at the legislative exemption, and they weren't able to reach an agreement. Start with, well, I guess we've heard the senator's position, so Professor, I'm going to start with you on this one. Should any of these exemptions be changed? What are the pros and cons of particularly having a legislative exemption?
So, okay, I mean, again, emphasizing that there should be access to public records, especially for executive agencies, because they have a much weaker argument to shield the agencies at the end of the day because they're not elected. That's not that built-in accountability. And you know, we're not dealing with matters of national security in Massachusetts, what I think is a big reason why you keep private, and also, but there's still issues of privacy that have to be considered. So, you know, it depends on how the exemptions work, of course, and that's something, if I was doing research on this, I would investigate. Certainly, you don't want these public records to be used for fishing expeditions, and probably they're not. You know, it seems as though Massachusetts has pretty good process in place to adjudicate requests for access, okay? You can make appeals, and thanks to the senator, I think since 2016, you can get it within 10 days, you get a decision on an appeal. So to me, it sounds like things are doing pretty well and fees are lowered. So things have changed quite a bit. You know, with respect to legislature, I still take my position that it's a deliberative body and it needs some insulation. And I don't think, I think there should be larger carve-outs in the public law for such an institution. The governor's office is the same thing. There is a form of executive privilege. Again, needing unvarnished advice. Not so much for the agencies, but within the governor's office, I think that's appropriate. Judiciary deals with very private matters. People who are incarcerated, people who have other issues. So I'm not sure the public records law should apply equally to these other institutions.
Senator Rush, you said that you believe that the legislative exemption should be lifted. So let me talk a little bit more about why, and then also weigh in on the exemption for the governor and the judiciary.
So, I've been thinking actually as the professor is speaking about the particular terms we're using. So I want to make sure that I'm clear in my comment here. Right, the public records law currently only applies in our state government to executive agents, offices and agencies, right? It also applies to various bodies on the local level, including, I might add, deliberative bodies like select boards, right? But so there's the question of the application of the law, which is the central question that I think we're talking about here, right? Should the law apply to the legislature, the governor, and or the judiciary. I happen to agree with the professor that I would not at this time subject the judiciary to apply the public records law to the judiciary, because the nature of that work is notably distinct. That having been said, in the federal judicial system, a lot of the documents, all the pleadings and things can actually be found online. Because of the way there's an electronic submission form and system that you can use. So I do think there's a conversation to be had there, but I think there's a little more nuance, more things to work out. When it comes to the governor and the legislature, I wholeheartedly believe, and in fact, I've filed the bill to apply the public records law to both of those bodies, but 3 bodies, right? The House and the Senate, right? The 2 different chambers of the legislature and the governor's office. That is, the applicability is distinct from the exemptions to what constitutes a public record, right? And there is a list of like 20 odd exemptions, and that includes, again, documents that pertain to the deliberative process, right? So when a policy is in the process of getting made, if there are materials that are written materials, right, a piece of paper, that is, or a digital record, which is of course where most of our stuff is these days. If that document is salient to the deliberative process, an exemption to the public records law already exists, right? That document would not be made public. That protects that kind of, honest and sometimes vulnerable conversation that the professor is talking about, and that I also agree is an important part of people being able to make a decision, a fully informed decision. That list of exemptions also covers private information, documents pertaining to security, right, other things there. And it is a very long list, and you can read it right in the general laws. That doesn't change the general question about applicability of the law. And especially given the various exemptions that already exist, I do not see a good reason to not subject the governor and the legislature, to make both of those bodies subject to the public records law overall, noting again the existing exemptions that we already have and that the executive branch routinely relies on.
I think we probably want to get to questions in a couple minutes, but I did want to touch on one other topic quickly, which is COVID. In some ways, COVID has really hurt transparency because it's literally closed the State House to the public. But in other ways, it's opened it up because you're live streaming a lot more. A lot of hearings are now broadcast, live streamed. There's opportunities for greater participation. Some people argue that this has equity benefits. It increases the ability of people with financial, employment, geographic constraints, people with disabilities, to be able to be part of the policymaking process. So I guess, Senator Roush, how has COVID affected your interactions with the public? And should any of these changes be made permanent? And then after that, Professor Raja, I'll just ask you to respond. Is it harder or easier to keep an eye on the legislature? And again, should these changes be made permanent? So Senator Roush, you're up.
I think there are pluses and minuses, as with most things in life, particularly these days. I think the greater accessibility, I spoke about this earlier, in terms of hearings, for example, is fantastic, right? People don't have to come to the State House in order to participate in a hearing anymore. They can do it on a live stream. They don't have to take an entire day off of work, if that's even a possibility for people, which isn't a possibility for a lot of people. And they can take, half an hour or an hour to, Zoom in, for lack of a better phrase. Although again, we use Microsoft Teams for the legislative hearings, and participate remotely. And that's, it's not only a question of socioeconomics, it's also a question of geography, right? If you live in Pittsfield, you've got a much harder time, North Adams, you've got a much harder time getting to Beacon Hill than if you live in Needham, which is where I live, right? And Needhamites even have a more difficult time than folks that live in Cambridge or Somerville. So we've got, I do think, a greater amount of equity, even in things that are not sort of publicly streamed, right? When the pandemic hit, and things shut down in March of 2020, I think that same month I held my first virtual office hours. And we have been having virtual office hours ever since. And people, again, they don't have to take time off. They can just, take 15 minutes. They get a set appointment where they can come and Zoom in and we have a conversation about whatever it is they want to talk about. And, and then go back to whatever it was they were doing before. That having been said, I think the closure of the State House not being able to really be in person together, and again, there are good public health reasons why it's both important. It certainly was important to shut things down, and why it's important to really do the reopening very carefully. That without people in the building, it is more difficult to kind of get a sense of the body. Right.
I think we're at time, so I'm going to let Professor El-Raja respond quickly, and then we'll take the questions.
Yeah, so real quick, I think access is good for hearings, letting people come in without it, but it's also an educative function, which I know the senator is very much into. She produces great videos for that. And for me, the question also is, it really does slow down the process. And I got to do a quick experiment. How long do committee hearings take? Because legislators will play to the crowd when they're being on Zoom and they're being recorded like that, more likely, which is not a bad thing, but it's going to take more time. The big perspective for me, big picture, is just to say that I'm worried about the institutions itself and how they function, given how low they stand, especially legislatures. And Massachusetts, by the way, is a very popular legislature compared to the rest of the country, probably one of the most popular. So I wonder, what is the problem being solved sometimes when we talk about this stuff? Doesn't mean they're perfect, but I think we should pause and figure these things out before the institution changes too much.
Thank you both. And Matt, I'll turn this over to you. I think it looks like we've got a bunch of questions.
Thank you, Shira, and thank you, Senator Rausch and Professor El-Raja. It's so great to hear an honest conversation about how our laws are made. Certainly as a law student studying laws, this has a lot of importance for me and my classmates. So I'll ask a few questions in the short time we have left. Paige Lieberman asks, Professor El-Raja has argued that allowing public committee votes or public testimony to be made more public, that it would allow constituents or certain actors to twist the words of what was said. I'm wondering, Paige Lieberman and I are wondering, Senator Rausch, since you do publish your committee votes, and I think some of your colleagues do as well, have you felt that twisting of words, or have you seen that twisting of words occur? I know that I'm asking you to argue against your own point, but I wonder if that's occurred.
So I would say I haven't seen that with regard to the publication of my votes. I publish my votes. You can go on to beccarauschma.com and I think it's even beccarauschma.com/votes, but I'm not sure. So go to the homepage and click the link. I have not experienced that. That doesn't mean it's not possible, but that has not been my personal experience. More where I have seen twisting is in the space of issues that are hotly contested and deeply polarized nationally and frankly internationally, that also exist in our state, both at the state level and at the local level, particularly around COVID and COVID precautions and vaccination. And that twisting is not about my voting record. That twisting is about a gross disinformation campaign that has been launched, worldwide, that the World Health Organization named one of its top 10 threats to global health back in 2019, even before COVID hit. So there's certainly twisting that happens, but at least for me, it has been entirely distinct from me publishing my voting records.
Thank you. Professor El-Raja, Elizabeth Campbell asks, you've mentioned several times that public records slows down the legislative process. If we're trying to make sure we have good legislation where the most people can participate, is slowness necessarily a bad thing?
No, slowness is not a bad thing, certainly on many issues that are complex. What I do worry about is sometimes you have to act very quickly, and legislatures are not designed to act quickly. So they have to take some shortcuts, and that includes giving leadership more power to move things along. It includes sometimes voice votes and things like that. So again, all of these things involve trade-offs. They all involve trade-offs. And I'm not against a slow process, but I think given the challenges facing the state, you have to really take seriously the need to move quickly on some things. And sometimes that does mean, shutting off debate or getting, taking in less information. More information is not always going to help you make that marginal call.
Matt, can I just make a quick point?
Yeah.
I just want to make sure again that the legislative body is in fact deliberative and takes much more time by design, but let's not confuse the legislature with the governor and the executive branch. The executive branch is the branch that is designed specifically to be able to take quick, swift action, including, for example, in a global health pandemic. And that is the body of our government in our current government structure that is supposed to be able to act quickly when the moment necessitates it. The legislature makes the laws. We don't make regulations. We don't make snap decisions. We are supposed to take time.
Thank you. Professor Laraja, would you like to respond?
No, I mean, I don't know who's to blame for this, but it always seems like, things are done at the last minute sometimes because things are so squeezed, but you have better insights into to that than I do, Senator. What's the causes for so many delays?
Well, it depends on which delay you're talking about and which issue.
Well, budgets or even the recent federal, American Rescue Act.
The legislature heard from hundreds of people with regard to testimony. Both of the House and the Senate have passed, different iterations of the ARPA legislation, and the differences are being worked out.
Right.
We're talking about billions of dollars of expenditures. Right. You don't want us to do that quickly. You want us to be careful and considered in how we spend that money.
Yes, exactly. I agree.
Well, thank you both. I think that we're running up against time. Lissy, do we have time for one more question, or should we wrap up?
One more question.
Okay. There's a question from Catherine Soderholm, who says that Representative Mike Capuano used to send an amazing weekly newsletter outlining all of the votes that had taken place, how he had voted and why. If people are worried about how their constituents will react, can't they do that same thing?
Yes. Not to put too fine a point on it. And that is something that I and some colleagues do. I don't put it out weekly, I put it out monthly, but the voting records get updated periodically, just right there on the website.
Yeah, as much information as the legislator wants to put out there to explain to constituents, I think that's great. You're not going to get an argument from me on that.
So with that, I want to say thank you, Matt. Thank you for handling the Q&A, and thanks to the Good Governance Project and Kevin Corcoran as well. Thank you, Sheriff Schellenberg, for moderating and being such a prepared and great moderator, Senator Roush and Professor Laraja. We started out this debate with the two of you agreeing on the overarching concept that transparency is essential for democracy. And then we digressed and achieved the very goal of these debates, which is to provide a forum to educate all of us in the nuances and different perspectives of complex and controversial issues. So you helped us achieve our goal in this last debate of 2021, along with my colleagues. We really appreciate it, and we want to say to all of you watching, if you have suggestions for future debates, please let us know. We would love to hear from you. Senator Roush, I commend you on behalf of all of us for never missing a vote. That is so impressive, really wonderful. So Thank you, everybody. Thank you, Rappaport Institute, for being such a great partner with the Rappaport Center. So from Catherine Carlson and myself and all of us, thank you. And I wish everyone a wonderful holiday season.